1966 ခုနှစ်မြန်မာနိုင်ငံတရားစီရင်ထုံးစာမျက်နှာနံပါတ်816 Wu Pei and two others appellant versus Sao Po Kham by his agent Dottin May Sao Thon Pha minor by his friend So Po Kham respondent ဤစီရင်ထုံး audio book ကိုအထက်တန်းရှေ့နေဦးအောင်ခိုင်ဦးအထက်တန်းရှေ့နေဒေါ်ပြည့်ပြည့်ဖြိုးနှင့်တရားလွှတ်တော်ရှေ့နေဦးထိန်လင်းဦးတို့မိသားစုကစီစဉ်ဆောင်ရွက်ပြီးဒေါ်ယူပါစောမင်းမှဖတ်ကြားခြင်းဖြစ်ပါသည် Civil Second Appeal before ဦးစိန်သင် Judge Wu Pei and two others appellant versus Sao Po Kham by his agent Dottin May Sao Thon Pha minor by his friend So Po Kham respondent suit for adjustment plea that permission was given by the owner to construct permanent buildings easements at whether a sufficient defense against the adjustment suit for adjustment plea of adverse possession constitution of adverse possession physical exclusive possession open and hostile with intention to hold for himself as owner. Hell, the Eastman's Act has not yet been enforced in this country and therefore the equitable doctrine cannot be allowed to prevail over any specific provisions of law concerned, even if it can be proved by the appellant defendant that he had been allowed to build a substantial structure on the land by the previous owner. This fact in itself would not be a sufficient defense against the adjustment sought by the owners. Madhuri versus Bola, Nat and others, AIR 1934, Allahabad 517, distinguished Kiwana versus Koton Singh and two others, BLR 1951, AC 188, refer to held further to constitute adverse possession, physical exclusive possession must be open and hostile with the intention to hold for himself as owner. It was not the case of the defendants that they had at any time any claim to ownership in respect of the suit land, and as such their pleas of adverse possession were untenable. Uthin versus Utho, BLR 1961, page 417, AC, refer to Ulanyo for the appellant, Uthontin for the respondent. Usain then judge. These three appeals, being civil second appeals, numbered 3, 4, and 5, were held together as the respondents were the same and the question of law involved was similar. Appeal number 4 was however slightly different, and I therefore propose to take it up first. In civil regular suit number 4 of 1961 of the Subdivisional Code of Taunji, the plaintiff respondents filed a suit for adjustment of the appellant defendant from a plot of land known as lot numbered 137 Sao Santon Road, Alibi Circle, Taunji. The plaintiff case in a nutshell was that they were the owners of the suit land and that the defendant, who was given permission by their predecessor in title to build a temporary dwelling house on the understanding that he would vacate the land whenever required by the owners, had refused to vacate it in spite of repeated demands. Insofar as is relevant for the purpose of the present appeal, the defense cited by the defendant was that he was permitted by the late Sopa of Mount Maestay, then the owner thereof, to construct permanent buildings thereon, and that in accordance with the said permission he had substantial buildings constructed according to the plans approved by the Taungji municipality. He also denied that there was undertaken on his part to vacate the land whenever required by the owners to do so. The trial court granted a decree in favor of the plaintiff with cause, and on appeal to the District Court of Taungji, the judgment and decree of the lower court were confirmed. Hence, the present second appeal, the only point that has been urged in appeal before me now is that as the defendant was a licensee who had constructed permanent and substantial structures on the land with the express permission of the previous owner, he could not be ejected from the same. The authority for this seemed to be the ruling in the case of Mathuri vs. Bolanet and others one, where it was held that even though the Eastman's Act does not expressly apply the principle underlying Chapter 6 of the Act, being in consonance with justice, equity, and good conscience, may well be applied, and that, therefore, when an owner of land gives permission to another person to put up a building of permanent character, and he incurs expenses in the execution of such work, the licensor is, by necessary implication, stopped from revoking his permission so as to prejudice the licensee whose possession has been compromised in consequence. It was also observed that it would be inequitable, unjust, and unfair to allow a licensor to order that the licensee should forthwith remove the work of a permanent character which he has put up after incurring expenditure. Thus, the ratio decidendi in the case cited above, by which the licensor was precluded from asserting his right of adjustment, was based on equitable principle embodied in the Eastman's Act. However, our late High Court has in Kiwana vs. Goton Singh and two others too expressed the view that in this country, where Eastman's Act has not yet been enforced, no equitable doctrine can be allowed to prevail over any specific provisions of law concerned. Thus, in the case cited above, it was held that where the previous owner has allowed a person to construct a permanent substantial building on the land without granting him any lease or any right over the land, and then sell the land to another person, and the purchaser requires the land bona fide for erecting a building, he is entitled to eject the defendant. Therefore, in the present case before me, even if it can be proved by the appellant defendant that he had been allowed to build a substantial structures on the land by the previous owner, this fact in itself would not be a sufficient defense against the adjustment sought by the owners. I would accordingly hold that the lower court was justified in decreeing the plaintiff suit, Appeals numbered 3 and 5, which are almost identical in point of law as well as of fact, arose out of civil regular suit numbered 3 and 5 of the Subdivisional Code of County, wherein the plaintiff respondent sought to eject the defendant's appellants on the same ground as in the former suit already dealt with. The defenses asserted by the defendants were however different in that they pleaded adverse possession. The defendant appellant U.P. by his written statement filed in suit number 5 stated that he had been in occupation of the suit land since the year 1946 with the permission of one U.R. alleged to be the owner thereof. In suit number 3, the defendant appellant U.R. likewise averred that he had been in occupation of the suit land since 1942 under similar circumstances. From the evidence obtained on the records of the lower court, it appears that U.R. was no other than the caretaker employed by the late Sopa of Mount Estate, the previous owner. Thus, the defendant case was that they were permissive occupants, and I cannot therefore understand how it could be said that their possession had been adverse to the owners, at least during the lifetimes of the late Sopa of Mount Estate and his employee U.R. There is evidence on record to show that Sopa of Mount Estate died about the year 1954, followed a couple of years later by the death of U.R., and therefore, even considering that the defendant's possession became adverse to the owners after the death of U.R., the suits were clearly within time. In U.Tin vs. U.Tho 3, it has been pointed out that there is great weight of authority and law is certain that to constitute adverse possession, physical exclusive possession must be open and hostile with the intention to hold for himself as owner. In the present case before me, it was never the case of the defendants that they had at any time any claim to ownership in respect of the suit land, and as such their pleas of adverse possession were untenable. It is common ground that neither the plaintiff nor their predecessor in title had ever been in occupation of the land, and therefore the law of limitation applicable was Article 144. The defendants were therefore bound to discharge the burden of proving adverse possession as laid down in Uchiton vs. Dongwei Tong and others 4, but there is nothing on record to indicate as to when their possession had become adverse to the owners. As to the correct meaning of the term adverse possession, the following observations made in P. Lakshmi Reddy vs. L. Lakshmi Reddy 5 are opposite. An adverse holding is an actual and exclusive appropriation of land, commons and continue under a claim of right, either enter an openly avowed claim or enter a constructive claim arising from the acts and circumstances attending the appropriation, to hold the land against him who was in possession. Angle, section 340 and 398, it is the intention to claim adversely accompanied by such an invasion of the right of the opposite party as give him cause of action which constitutes adverse possession. Applying these principles to the present case before me, it is impossible to hold that the possession of the suit land by the defendants have been adverse for more than 12 years. In the result, these appeals fail and are hereby dismissed with cause